AO sir, registrar sir, all the deans, head of the departments, faculty members, and dear students. On behalf of Institutional Innovation Council, JSS Academy of Technical Education, Noida, in an hour-long session on intellectual property rights and patent process. For the same, we have our technical expert, Dr. Bharat N. Suryavanshi, Assistant Controller of Patent and Designs, Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, Maharashtra. So I cordially welcome you, sir. And before going ahead, I would like to request, thank you, sir. Before going ahead, I would like to request Professor Sampath Kumar V, IIC convener, innovation ambassador, and yes, of course, MBA Nodal coordinator of JSS Academy of Technical Education, Noida, to share his insights and his opinion on the same. Over to you, sir.
Thank you, Sapna. Thank you very much. On behalf of JSS Academy of Technical Education, Noida, and its management, and also on behalf of Institute Innovation Council established under Ministry of Education, Government of India, to promote the innovation culture in the higher educational institutes. So I welcome Dr. Bharat Suryavanshi, and it is our honor and pleasure to have you for series of innovation lectures we organize to help our young and bright students in the campus. So I welcome you, sir. And just to brief you about our institute and as well as about Institute Innovation Council, I will not take much time. Quickly, I will take you what exactly we are doing. So we started this Institute Innovation Council under the Ministry of Education in 2018, and its main objective is to conduct a series of webinar sessions, online and offline, related to startup culture, innovation, prototyping, design thinking, and critical thinking, and also many other activities related to business model canvas and innovative business models, and the related to patents, all IPR and IP management issues, and this gives an advantage for our students because in the beginning of their engineering education, before starting their professional career, so they will be exposed to interact with persons of your profile, and it gives the exposure for them, and also they will feel confident. So how, if they have any idea, so how, who, and whom they have to approach, how they can convert idea into a prototype, and also where they can apply for different competitions. This is a council, we help them, we mentor them, and we conduct series of sessions, and also we will give them an opportunity to visit nearby startups, and also we will hold session with the successful startup, the experts. So with overall of this kind of ecosystem, we do, and in 2018-19 we got 4-star ranking from the Ministry of Education, and for 2019-20 we got 4.5 golden star rating out of 5. So, and this time with the help of all our industry experts and academic experts, efforts, we are quite confident that we will be able to achieve 5-star golden star ranking in the Ministry of Education for academic year 2021. So with this, I welcome you, sir, for this session, and definitely we will be interacting with you for few more sessions, and also whenever we organize the innovation contest, we will take your help and guidance, at least not for all students, at least one or two group of students, and kindly help us, and your help and your time definitely it is going to contribute to the young people in this region of the country. Thank you very much, sir. And over to Sapna Madam.
Thanks a lot, sir, for briefing us regarding the IIC cell and the need for fostering innovation and such culture. Now, I would like to request Dr. Yogen Singh, sir, Professor, Training and Placement Officer, and yes, Innovation Investor. And I would like to request him to share his insights and his opinion pertaining to IIC cell and requirement of innovation and fostering the same. Over to you, sir.
Sir is not audible.
Yes,
Sir is not audible.
Yes, sir. Yes, sir. Not audible.
You can invite the expert to take over this session, and at the end we will invite Yogendra sir to address.
Fine. I think so there is some connectivity issue with him, so we'll go ahead.
Hello?
Yes, sir, you are audible now.
Hello? Okay.
Hello.
Respected principal sir, EO sir, AO sir, registrar sir, Sampath sir, the LMB coordinator of JSS, IIC coordinator of JSS, and the PhD of MHID, and Dr. Sapna Madam, all HODs, and especially Dr. Bharat Suryavanshi sir. First of all, myself, Dr. Yogendra Singh, I welcome you, sir. And sir, thank you very much for accepting our invitation for enlightening the academicians, students, the faculty members regarding the very important topic, that is the IPR, which is the need of the hour. That is, and this basically helps us in making the strengthening the nation, where we are talking of increasing the innovations. And this program we are conducting under IIC cell of our college, where the Sampath sir is the coordinator for that. So, sir, thank you once again. Thank you very much. And it will definitely, this initiative is leading us towards making the Atmanirbhar Bharat. That is, we have to promote innovations, we have to promote IPR patents, and we have to develop a habit for our students, for the faculty, and all the entire fraternity. So once again, thank you very much, and we'll keep on bothering you in future also. So kindly enlighten us, sir. Thank you very much, and thank you, Sapna Madam, for giving me this opportunity. Over to ma'am. Thank you, ma'am.
Thanks a lot, sir. Now I would like to request our technical expert, Dr. to enlighten us and especially to enlighten our young minds. That is our students for the topic which is intellectual property rights and patent process. So over to you, sir.
Thank you, ma'am. Most welcome to you all for the IPR session. As you might have known, because you all are doctorate professors about IPR, even though I will enlighten with the detailing intellectual property rights. Say in the slides.
Yes, sir.
To see, are you able to see slides?
Yes, sir.
Yes, sir. Yes.
First of all, I give overview of my offices where we are working. We are working on the Ministry of Commerce and Industry, Department for Promotion of Industry and Economic Growth. Within our office is called as Office of the Control General of Patents, Designs, Trademark and Geographic Indications. We are having 4 patent offices: Kolkata, New Delhi, Mumbai and Chennai. PIS 82 from Pakistan, now named as Rajiv Gandhi National Institute of Intellectual Property, Nagpur, is the only one center in India wherein we are training for the professors, students, teachers, law graduate, and company professors for the all IPR. And also we are having international seminars with respect to world intellectual property rights with the different countries to practice how they are practicing the patents, what is our law, how we are practicing. So we are having bilateral relations and we are having every summer classes and many other things in the foreign countries. We are having trademark offices at 5 places in addition to 4. One is in Ahmedabad, where all the trademark processes are going on of the 5 of the offices. GI is Geography Indication Office and Appellate Board, very located at Chennai. GI is Geography Indication. Appellate boards look after the disputes of the IPR, that is patent design trademark and geography. Whatever disputes are there is resolved in the appellate board. These are typical of our offices. You might have seen Delhi office, Mumbai, Chennai and Kolkata, our 4 cities. It's our training center where we are physically also we are having classroom training, but because of COVID we are also giving online trainings for the people. 1 day, 1 week, joint programs, half day, full day and free programs. This is our website where you can get all the details about filing of different intellectual property. Again, we are having the updates on the social media. You can go and visit. You like also if you want. You can visit to Facebook of RGNIIPM and also Twitter account of RGNIIPM. Let us see what is intellectual property. Intellectual property is a product of mind. That means any kind of property, form of tangible, intangible, that is a product which comes while discussion with the friends, or sitting in the classroom with the friends, or you are in the labs, or you are in some seminars, or if you are thinking some problems, automatically solution comes to your mind. That is nothing but an intellectual property. So, for example, since last year we are facing the problem of COVID, so many companies are trying for the composition of vaccine. So that was a problem. Many scientists and universities of foreign are working on that. Finally, we got some, but not at the final trials we ordered, but we are using the vaccine. So such type of thing, any problem comes, our scientists depend on the field are doing something that is intellectual property, which comes from their mind while doing the practicals and when they apply art something, but we are giving the output. That is an intellectual property. Let us see overall view of what are the different kind of properties. Here, if you consider property, there are 2 types: tangible and intangible properties. Tangibles are movable or immovable. You can see car, buildings, plot, gold, they are made. These are the property people things which can give you return, but not other properties. But there is another kind of property which is called intellectual property, which can get more return than the property what is there in the tangible. Once you are having the patents on your name, a design, a trademark, you can earn like anything as other kind of property by licensing or by technology transferring one to another. So here, intellectual property again, industrial property and copyrights. Industrial property includes patents, designs, trademarks and geographic indications. Let us see one by one different kind of intellectual properties. Intangible property. Intellectual property means intangible creations of human intellect having commercial value, assets are like any other form. Means IP is also considered property like any other kind of property because it is given in turn because of licensing. When anyone comes to the formula of vaccine, when they are earning like anything because they are licensing to other companies in turn they are. Therefore, it's a one kind of property wherein you can get all the returns about compared to other kind of law. There are some intellectual property rights. Patent is called as exclusive right because once you register on your name, only you can enjoy the rights. If you want to do license, you can, otherwise you don't. Therefore, it's also called as negative. Patent is an derivative right because whenever you are applying to India, it's valid only in India. You want to get right in other countries like PCT and convention countries, you are supposed to file application by means of patent corruption or through the conventional route to get them established your right in the other countries. Patent is also called as licensable right because once you are having patent on your, you can license it to anyone whom you want, whatever the value you decide by IP valuation. What is the significance of intellectual? It avoids duplication of research, encourages the creation of wide variety of intellectual tools, helps industry to improve existing technology to produce better future products. Here, if you are sitting at Noida and VNIT is in your Nagpur, they are carrying out the research on the same subject matter. It becomes a waste of manpower, money. Therefore, it's must, whatever you are doing, you have to file IP, publish in every journal, every week, so that the field of mechanical can see the mechanical techniques, electrical can see electrical, electronics can see. Depend upon that, they can choose their research topic or project for where they are working. Otherwise, it becomes duplication of the research. And such no value at all. Utilize the public witness restriction always before going to start your project, completeness, or PhDs or any other work, whatever. Transferring the invention as a public property after expiry of term or cessation of the term. So every 20 years it's expired, then anyone can in public use the patent specification for studying and they can improve that, providing reward as a exclusive right for only if you are disclosing everything as per section 10.4 of the patent act, you are getting that one. Because you have to disclose fully and particular. Many people come to us, especially from the teaching. Sir, I am having invention. There are 4 steps. 3 steps are I am telling. 1 step I am not telling. Without that, invention will not work. It's not in. Once you are disclosing the office of IP, the time and date counts from the date of publication. Therefore, you are supposed to disclose fully. Then only government is giving 20 years right for the invention to practice. Royalty on technology transfer analysis. You can get royalty for that full disclosure on technology transfer. What is patents? Exclusive monopoly privilege rights granted by the government to the patentee, who is currently the person who has filed the application and patentee for 20 years from the date of filing or PRT for commercial gain, concession to full disclosure of his invention as a territorial and not in worldwide. I told you it's only valid in India if you are filing in our own country. There are again many people are in confusion with what is discovery and what is an invention. Discovery means finding something or exploring which is already existing. Discovery assesses no technical effort. For example, there are metals in the periodic table. Something you are isolating new metal from the earth, that is an discovery. But the method what you are employing to isolate that metal is an invention. Because you might have using some new machines, new steps, new chemicals, whatever the parameters you are applying for that. That may be new, but the method assets is new. Another example is the field of biological sciences. If you are isolating the bacteria from jute industry or cement industry, the bacteria is already present the effluent of industry. But just you are isolating by applying the method, changing temperature, media, whatever the pH. So the method of isolation of bacteria is maybe new, the steps are new, but as such microorganisms which are isolating is an discovery. But genetically, if you are modifying something with mutations or any other technology of recombinant technology, that may be genetically modified or depend upon the genetic criteria that decides whether patent office. But it's must to know what is discovery and invention. Only inventions are patentable. Invention means new product or a process. If you want to file invention, you should say should be product or a process. Many things I am having idea, I'm in some platform, then I file. These are many questions comes to our training center because we are having some the queries of many people because India is still developing and we are getting no awareness about the intellectual. Therefore, if you want to file patent, it should be product or process. That should be useful, novel, non-obvious, not public's knowledge before the return. That's why we are publishing papers. We are even see what is there in the prior art or in public domain or literature. So it should not be there in the public domain to consider the invention. Simple example I give you. Sharpener. Sharpener is now everyone is using. Every company is manufacturing. But in the year 1822 was a technology. It was new. So Mr. C. A. Boucher has filed the patent in Paris. He was in Dubai. But how he has written that claim? Because patent is a techno-legal document. Therefore, he has written tool for sharpening a pencil, writing point by saving away its own surface. So how he has written? It's not sharp simple. The way of drafting the claims he has drafted in the way. He has got patent. Now it is in public domain of 20 years, so everyone is enjoying the right to manufacture and sell in the market. Another example is electric light bulb. Perhaps one of the famous invention, the 1817 by Thomas Alva Edison. But we are not stopped with the electric is known. Still, electrical engineering people are doing research to get a more advanced version, that is LED bulbs. That technology was patent because you are doing improvement over the technology which is existing. And that bulb consumes the less electricity, gives people less bill. So that's an advantage also, it's useful also. You cannot stop with the technology known. You have to do an improvement over the technology what is there in the public domain. Another example you can see telephone. We know in old films we are seeing this telephone. If you want to connect our near and neighbors, 10 times you have to ring, connect the number. So this is a disadvantage of that. And we cannot take one place to another place. To overcome that, we got new technology called this phone. You can take from kitchen to hall, hall to bedroom. But again there was a problem. You cannot take in the meetings and also. Therefore, mobile phones came in the market. Why? We are doing improvement over the telephone which is in the 1876. Alexander has got patent, he has enjoyed the right, but now we cannot sit with that technology. We are doing improvement over technology. You can see Nokia is having different patent, even Samsung having, again Oppo is different patent. So every company has their own technology and they are got patent. Not only patent, I see how the relations of patent, design, trademark, how they have put their own brands in the market. This was a recent example. We are seeing 1822, 1872 like that, but it's an example of 1994. We don't have any option for data transfer, but John Hudson has devised what is called Bluetooth. He has got credit for that. Bluetooth is an option for data transfer. Earlier we are not having, but we being Indians, we have never thought of doing such inventions. Most common mistakes by the Indians. We publish their invention before the filing of the patent because they may not be aware of that. Are they going to some seminars and they are disclosing? Are they doing some conference or disclosing? Don't know, but they are disclosing. So it's not the thing. Use of the in public or commercial use, mention even in secrecy to prior filing the document. Always maintain the secrecy until you file the patent application. If you are not sure that your patent is worth, wait until fully developed. Then you can decide it is worth, you can go for the filing. Let us see another kind of intellectual property, design. Design means shape, configuration, pattern, or ornament, or composition of lines and color combination thereof applied to any article, 2D or 3D or in both the forms. It is appealing to the eyes, looking at product, attract consumer. Mere functional or technical feature of the article are not considered. Only how it looks. The cup sets how beautifully it is looking. So, design. And the term of design is 10 years. It can be extended up to 5 years. Total term is 15 years. we are using this machine, that's also registered design. There are different products in the pharmaceutical, ampoules, capsules, thermometer, all are registered ones. So if you are making new designs, you can register. Textile designs, jewelry also, you can see different kind of designs. Whatever new, that can find and get a benefit out of. Let us see another IP trademark or brand. Visual symbol, which may be word, name, brand, numerical, or combination of colors indicate the shades of the goods. To distinguish from the goods of the others or authenticity of the goods. Once we say good, very good. So Reliance, good company, can purchase. So blindly we are believing because it's brand. Coca-Cola, good drink, because by name, Amazon, good site to book something else or purchase something else. So by name, because brand. So anytime you are starting your own startup, you have to do the name. You are doing MSME or own shop, also you have to put the name. That is the trademark. You are putting the name for the logo. If you are creating, you can register for that also, so that any competitor will not copy your name or brand. You might have seen many people advertise goods and services, protect the innocent public from buying the goods of second hand. We see Adidas name actually what is registered one, but there are many shoes companies which change the spelling Adidas in the some, they put something in ADI place in ADN themselves. We never see correctly says this company because it's our mistake. We have to know exactly brand, what the name, what is the registered company. Then only you have to. Otherwise, there will be many people are in the market who are selling the second-rate quality also. R and Circle is a trademark which is registered. You can see water bottles, many of the products which are there in the market. PM is trademarks you are applied, but you have to get the brand or registration of that mark. Duration of trademark is 10 years. You can renew every 10 years if that mark is in use. Geographical indication means placement used to identify the source of origin, quality, reputation, or other characteristics of products. Example: Darjeeling tea, Kanchipuram silk saree, Uttarpuri chappal, Agra peda, Nagpur rajes. Recently, one of the GI is mushroom of Jammu Kashmir. Again, Rasgulla is also registered by the Bengali people and also Odisha. These are the different GI depend upon that. Here, patent, design, trademark. Any person or comments to other person or company can file the IP, but in job indication, a group of people has to. For example, Nagpur rajes means a group of farmers from the Nagpur are registered the IP. So, a group of people to register. The term of GI is 10 years. It is in use. You can renew for every 10 years subject to the usage of your GI. Copyright means provide this holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. Term of production is life of the author plus 60. You might have known many singers have sung the song, recorded, but still they are getting the royalty because life of the period of the copyright is term of the copyright is life of the author plus 60. Because of that, they are getting royalty. It's a brief overview of the different IP. Patent is given for only technology. Design is for different designs. Name is for trademark of Bata, Tata, Bisleri, Yahoo. Copyright is for the. Now, how you are having a link with different intellectual property? How you can protect your products by different intellectual property? Same Sony TV. When we are in 10th, 12th, it was very famous for its clarity of picture. So, Sony company has got patent for an invention remote control mechanism can be protected. Because it's an invention, product or a process. He uses this. So he has got technology patented. Trademark Sony name got registered trademark. And the aesthetic view of the Sony is by registered design. And the instruction of the Sony, which are there in the box of the TV, it is manual, how to operate and other things, that is copyright. You can see there. So single Sony TV has protected by different kind of properties so that Samsung will not copy out anyone now his name as a technology or copyright or the design. Therefore, you're starting your own startup, your own company. Don't forget to get protection for trademark, this technology, product, technology for patent, copyright and design. Another example for a trade secret. Trade secret is that which is within the people who work in the same company and they have been taken non-disclosure agreement with their colleagues or the people who work in the same company. Here we can see Pizza Hut is different from hotel to hotel. Pizza Hut many hubs are there, not everywhere they are getting the pizza, but taste system. Here that is trade secret. Something they will add which will enhance the taste of the pizza. So they can also get protection for the trade secret. Mark the name of the hotel, name of the pizza is trademark. Design is how it is made. Patent is for the technology, the process of making fluffy dough, or the device or the instrument using for the that's anything else also. This is the one product can be protected by the different lengths of copyright so that other will not copyright. These are the designs. You see, you take your mobile, somebody saying Oppo, something Samsung, Nokia, mobiles, Vivo, different mobiles are there. You can check the design is totally different of each mobile in some or other way. Even megapixel cameras different. And the technology combination of hardware and software also different. So Nokia got patent, Samsung is having patent, Oppo is having patent. Why? Because they are different. Technology is also different. Even for design also. Single product is protected by the patents, design, trademark and copyright. What can do with IPR? If you are a science graduate, you can become a patent agent. Every year our office qualified for the call for the post of exam for the patent agent examination. So any science graduate can apply and if after passing it, we give a patent agent can practice on its own, or you can work in some company, or you can work in IPR cell, or you can work in NGOs, IPM firm, and we can also join in the government. Any PE fellow is able to join as an examiner of patents and design in the government of India after writing the exams conducted by the office. Any law graduate or commerce graduate can practice as a trademark agent or copyright. Thousands of scientists and faculty, students can also be named by simple approach. How? While carrying your research or a project, identify some problem which is near and nearby, or in the field of view which are mechanical, electrical, or electronic. Then solve that problem. You can apply for the patent, and again, don't forget to take non-disclosure agreement within your colleagues or clients. Here, we think everyone is using gas cylinder in the house. But what we do still, we are being in 21st century, software era, we speak that in 20th century, we know everything, and we are flying in the sky. But still, we are lifting our gas cylinder with both the hands, seeing how much gas is remaining if we want to put the next. Why can't we have a knob with the which indicates how much gas is remaining? It's a problem. Somebody has to solve it, and we will solve it also. So, and technology, simple problem. Since long we are using, everybody in the kitchen, but again we are lifting ourselves in the both hands. Why is so? Being in 21st century, we can call it software era. We are still following the manual rules to some of the technologies. So always try to solve a simple problem. That's an invention that can help in trademark. What can be patented? country has their own law. Depend upon that, country decides what to be built in India. Depend upon the patent they are licensing as well. All processes, products which are new, involving an inventory step, capable of industrial application are patentable, and some of the sections, section 3 and 4, which have been given details what not be given patent. So it should not be not barred by section itself. Product includes apparatus, device, machines, and chemicals. New means what? Published in India or elsewhere. By searching our database, once you find the application, we not only search in Indian documents, we search overall world documents. What is there for you file your patent application? We consider the date of filing is yours in that. Before that, what is there in the patent? We start in our patent databases, and I'll see if you are not getting documents, we will go for the free databases. In prior public knowledge or prior public use within claimed for in any specific in India or even you check for the prior claim also. What is inventory step? A feature of invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that makes invention not obvious to a person's here it may see. One is of it should be technically advancement, economic significance or both. The process of preparation and beverages from the sugar molasses. We are having process since long, existing in the nature and conventionally they are using that. But 1 quintal of sugar molasses are giving just 50% of clean with the 50% purity. Somebody designing new apparatus or a machine that can give 90% of purity and 90% of more yield, automatically that is economically significance, even economically add-on. That fulfills the step of the invention. Who is the person stealing that? For example, the invention relates to electronic, and the person who is electronic, who knows the basic knowledge of electronics, he thinks that this invention is carrying out does not require any experimentation, that's obvious to him. Wireless telecommunication. It's a technology which is developed from the telephone. But the people who is in the field of electronics, he knows what is the requirement for the developing a device which can work without wires. If it feels it does not require any experimentation, that's technology is obvious to him. So that is depend upon the person who is feeling the art. How we can say which your invention is indicating an inventory step or fulfilling the requirement of inventory step? We should have surprising result. How surprise is it? Paracetamol what I am taking today, if you consume now at lunch time, it takes 8 hours to cure your or reduce your fever. But somebody comes with a paracetamol composition, you consume now within 2 hours, you are reducing your fever. That is something surprising result. Technology can be created because drastically 8 hours is 2 hours you are doing exams. That is surprising. Solution to a long-standing problem. The conversion of wind energy into electrical energy. Since long time wind is there, but nobody thought of conversion. Now we are having devices to convert wind energy. That's a solution for that. Fulfill it up a long period. I told you gas cylinder example. We need since long time we are feeling that we require a knob. Indicate the pressure so that we cannot use the cylinder. But still we are falling. If you are solving that problem, that's also a solution for it. A great technical problem. Something you are doing, improvement in the technology, that's a great thing. For example, earlier telephone was Alexander Graham Bell telephone, which 10 times you have to type. But now mobile, it's a great technical problem. Because you can do video calling. So the technology you are sitting at Noida, I am here, we are talking to each other. That's a technology. That is pretty good. This is an indication of the obviousness. Industrial application which should be made of use in the industry. There is section 3, wherein some of the inventions are not patentable as mention, as per section 3A, frivolous which claims anything obviously contrary to the well-established natural laws or not. Machine that gives more than 100%. It's not possible. It's not valid. Machine giving alleged to be giving output without any. These are the frivolous one because everything by input will be output. As per section 3B, invention, the primary or intended use or commercial exploitation of which could be contrary to public order, morality, or which causes serious risk to human, animal, or plant life, or health, or to the environment, or nothing. Because any device for theft, gambling, apparatus and method for gambling, method of food adulteration, these are not pretty one essential. This I told you near discovery. Such type of invention not pretty. PD is for the most of chemical drugs. Mere discovery of a new known substance which does not result in the enhancement of known efficacy. Yeah, I am lecture, so will be important. Because I am in lectures now, it continues to be the same. Thank you. Sorry for interrupting. The discovery of new form of a known substance which does not result in the enhancement of known efficacy. I told you efficacy in the case of paracetamol. So it does not result in the mere discovery of a new property of a known substance or not the unless it should show result in new product or implies new reaction. Esters, polymers, ethers are not the unless they prove it efficacy. You might have seen, I'll tell you now what this drug has been rejected because it is not proven the efficacy of that drug. For example, use of a aspirin for cardiovascular disease, which was earlier used for analgesic purposes, not something using earlier, and you are telling that new use of that is not very good. This is one of the drug filed by the Pfizer, and I have the only control. I have given the decision. This drug name is Professional for arthritis, filed by the Pfizer. They told that it's a new and proving the efficacy. Wherein when I taken this for examination, I found that the invention disclosed and claimed in the instant application is not considered invention because I do not admit that this is not any efficacy over the base compound what the same company has claimed in the earlier. Therefore, in India, I have recently consulted the newspaper. If you put in the Google also, it's my own decision in the 7th September. In India, Pfizer predicted this rejected the patent. It's not this case I told you. As per section 3, substance obtained by mere admixture resulting only in the aggregation of the properties not predictable. For example, mixture of sugar and some colorants in water produce soft drink is mere admixture. But combination giving synergistic effect or predictable. I told you synergy. Synergy means something A plus B being more than that. You know only. You are taking case of because synergy can be shown in the case of chemical or pharma example only. If I am taking tulsi plant extract, Inca plant extract and other things. The combination of three, if I am able to do something respiratory and infection disease, it's a compound. But each one, even for the respiratory, we are taking in the form of extract, it's called kada and all. But if we are showing extra effect, but combination of three, then it can be seen for the particular. As per section 3 of mere arrangement or rearrangement or duplication of known device, each functioning independently of one another known is not that better. For example, you are going the dark to fetch water from the well in the village, attaching torch to a bucket or fitting torch to a bucket, you are telling that I have solved my problem in minutes. No, because bucket is different, torch is different, both are known in the public domain. Just you are doing arrangement or rearrangement of known devices to solve your problem. You want to go in the dark, so you are solving the problem so that you cannot hold in the hand, so you are attaching your bucket. An umbrella with a fan. You are going the hot summer, holding in the umbrella, again you are feeling hot, so you are attaching small fan so that again you can think more. So solution to problem, but not in technological, because umbrella and fan are different and both are known in the balance. Clock and radio unit, single cabin. So such type of many examples are there. Helmet with a fan. Here workshop improvement fails to printable, the improvement or the combination must produce new result or new article or better or cheaper article than before. Then we can consider. There is no working interrelationship between them and our devices are capable of functioning independently. As per section 3F is very much related to engineering sections, so that the arrangement or the rearrangement of devices are not done. As per section 3S, method of agriculture or horticulture is not mentioned, but the agriculture equipments like John Deere company, tractors, the machine for sowing the seeds, such type of dimensions are present. As per section 3A, any process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or any other process for simulating the animals to render them free of disease or to increase their economic value or market value in India, wherein other countries the method of treatment is going on in place. Therefore, method of treatment of cancer, method of treatment of dental plates are not, but the device for surgery, weapons to have the X-ray device, scan device, such type of device, something new, combination of hardware to software, such type of device are treatment and section. Here the as per section 3J, plants, animals in whole or any part thereof other than the microorganisms are not protected, because these are what protection under the Plant Varieties and Farmers Act 2006. Therefore, it's dealt separately by the as per section 3K, computer science, engineering, and software engineers, mathematical or business method or a computer program per se or algorithm is not printable, but the combination of software with the hardware like ATM machine, washing machine, such type of dimensions are mobiles are printable, mobile phone, because combination of software with the hardware. Method of controlling traffic, scheme or method of bookkeeping, business method, method of tax collection, computer program per se is not printable. Algorithm, no. Section 3L I told you, literary dramatic text, books of the copyright act, get separately in the separate offices, copyright office located in the area. Section 3M, mere skip or rule or method of performing mental acts or method of playing game. Such type of dimensions are not printable. Method of learning language, method of playing chess, method of teaching and learning are not printable. As per section 3M, presentation of information is not printable. You might have seen daily timetable seems common, but it's not printable because there is no technology at all. You are just communicating. You can communicate any kind of signals, that is method of presentation. Topography of interior circuits is three-dimensional configuration of the electronic circuit using the microchips and semiconductor chips are not printable. Section 3P, invention which will affect traditional knowledge, is an application or duplication of known properties not printable. Because we know Nikitonic bring blood over this is known one. Turmeric for wound healing. You might have heard we have revoked the patent which are bought by the US, that is for the turmeric and healing. Because we are having so many years back proof that we are using this as an medicinal properties. And for neem, pesticidal and insecticidal properties of the neem also. We know our ancestors used to store our food grains by applying the dry leaves of the neem in the tank or small water they used to make from the villages. Once the application comes to our office with this knowledge, we search that in EKD library. It's called Traditional Digital Library. In that we get all the recordings of our ancestors or our scientists who have recorded each plant uses. If you found something in that, you never give patent for that. You reject the patent under section 3. Again, there is section 4, wherein the inventions we used to atomic energy are not printable. Inventions relate to compounds of uranium, beryllium, rhodium, plutonium, radium, graphite, lithium, and more as notified by the central government from time to time. Such type of inventions are not. Such type of invention if comes, they write to the Ministry of Defense that whether it falls under the atomic energy or not. They give permission, then we will go for the publications. While you are writing your application, what is the objective of your application while writing that? You should have a technical part, the detailed description of invention, background literature survey, how much useful, if you are having ranks explanation, a detailed summary, advantages, then finally comes claims, what you want to claim. One example I want to give here, you can check the pen which you are having in your hands, how it is. Title is foldable pen. It's drawing of the pen. You have to mark each drawing 1, 2, 3, 4, 5 like that. And because this marking is very much essential while writing the description of your invention, what is there. So, another one drawing. This is form 2 wherein you are writing to all the application. Title is foldable pen. Applicants under Noida College of Engineering. Address so and so. And the preamble is different from provisional to complete application. Provisional is different, complete the following specification, particularly describe the nature of this invention and the manner in which it is to be. Here, field of the invention which relates to the process is relates to pen. Here, this invention relates to a field of engineering wherein the conversion of mineral is very electrical. So, depend upon that you generate. Background of the literature survey, what is there, you are supposed to write it out. What is the disadvantage of the earlier pen so that he is bringing the new pen in the market? He has given me here. Again, summary of the invention. Overall research, what is the summary of this? What is the advantage over the hierarchy he has given here? Statement of the invention. Here, you have to give detail about your product. How is my pen is now? A foldable pen comprising flat body of water shape, molded to form two larges in the depression in side body. Side depressions acting as hinges and two panels such that body may assume two distinct shapes either virtually or quadratically. It looks like a prism. Second part of pen is hollow reservoir located at one of the panel for storing and dispensing the ink. Third is rating tip extended into the reservoir for dispensing the ink. How the pen is drafted in the techno-legal language. We are told first part how pen is, second how it is reservoir the ink, third part is how it is dispensing to write the ink. These are the parts of the claims and which comes in the claims. These are the detail about the pen. Again, now he is giving brief description of the component drawings. Each drawing you have to give how they are in the figure 1 is a perspective view of showing pen. Figure 2 is also another view. Figure 3 is also another view. And figure detailed description how figure 1, 2 and 3 are connected to function as a pen. They have given all detailed description is done. Now finally, if individual I claim, if you are filing on the name of company, we claim a combination of 1 or 2 authors or with the students, we can write we claim depending upon the name of the company. Foldable pen. The flat body comprising has given all the first claim is principal claim, which should define all the essential feature of the pen. Because you cannot add anything after filing the patent application. Before that, how much you want to add you are supposed to add. Because amendments are allowed only under section 57 by way of correction and explanation and disclaimer only, not by addition. Therefore, whatever you want to write at the time of writing of the application. Dependent claim how they are written. Each part again they are telling. Foldable pen has great claimant where the panel is of the same size. Panels are beveled. It looks like a truncated pyramid, wherein we are having reservoir. These are the preferred embodiments, features which are essential to work in a bank. Lastly, you have to give date and signature of the first. Otherwise, you get the objection that a wireless communication device. The direct conversion of quadrilateral receiver is known for using cellular radio system. Such a receiver is designed for a single system and is not suitable for other systems having different frequency band and signals having different bandwidth. Instead, electronic fellow or telecommunication fellow will know better than how to draft the electronics related inventions. So, it's must you are supposed to bring all the essential feature of your invention where the exact new is live, where the inventory step is live. You have to put the examples as I told in the pen. So the claims again we have written 1 or 2 3 claims of wireless communication. Total 4 claims are there. Given main claim and subordinate claims. So another example, dog umbrella. So an invention is spread in the US. If we take our pets to walk, if it's raining, we see some tree, we go under tree or see some roots. But here is the invention. You put this umbrella can saves your pet to getting wet from the rain. You enhance this attractor device. It's a device very attractive so that it's easy for the people who catches the fishes for daily use. This is done by the Progress rate. File the patent is the patent number for that. Now you know different kind of intellectual property, how the patent application, now how to file a patent application. As per section 6, any individual, natural, Indian or foreigner or legal entity, company, anyone can file a patent application. Startup or joint filing, anyone can also file the application. You can file physically, going to the different patent offices, or if the jurisdiction is there, you can go and file, or by sitting in your office, you can file electronically. As since July 20, 2007, we have given opportunity to file online also. There are different jurisdictions. As you are in Noida, so you daily your jurisdiction to file the patent application. Mumbai close, state of Gujarat, Madhya Pradesh, Goa, Maharashtra. Chennai close, state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu. So we are having 4 jurisdictions. Depending on that, where you are residing, that jurisdiction you have to choose and file your patent application. The documents required of filing are, there are some documents which are very much essential for the filing. Form 1 is required, Form 2 is for proof of right, Form 2 is for provisional or complete you have indicated. Form 3 is for the statement for foreign filing dates. If you are filing your invention, India as well as in foreign, what is status going to the foreign country that you have disclosed in the form. Every 6 months, if you fail to give it 6 months, you are supposed to pay the petition, the fees to condone the irregularity or delay in the submission. Form 5 also declaration of inventory. Once you want to hello.
अभी audible sir, अभी audible sir.
Sometimes maybe technical error.
Yes sir, yeah, you are right.
If you want to file a declaration of inventory, again you have to file within 6 months. Otherwise, you are supposed to pay the fees for that. You cannot. Once you forget to file the declaration, then you come in the opposition also. A request of examination is form on file on form 8. Drawings can use sequences, electronic forms, abstract you have to use. If you are filing physically, check, read it, you can bring to the office and you can file, or you can file online also. Some forms are optionally required, that is form 9. If you want to early publication and you want to pay extra fees, then you can file for that. Form 26 for the power of attorney. If you are not writing on your own application, you are assigning somebody that is with agent, then Form 26 is a must. You have to file. If you are filing an DCTR convention application, certified copy of the prior document must to file the application in India. Otherwise, when the control asks, you are supposed to produce the copy of the prior document. The basic filing is Rupees 1,600 for natural person, and Rs 8,000 for the others after 30 pages of complete application. Even more than 10 claims in that application is a filing, we charge per claim also 160 per individual and 800 for the companies. If you are filing hard copy, that is 10% additional fee you are supposed to pay for that. This for formatting, 4,000 for natural person, 20,000 for the other than the natural person. This form 9 for request for early publication, people will find it, 12,500 for the company. Once the application published, it gives application number, date of filing, publication date, title of the invention, classification, your name of the applicant, and inventor name also. Again, abstract, how many claims and how many claims. Depend upon this abstract, any person can upload that is for patent application. Because they know the technology, somebody is a mechanical engineer and file the application, they know that this is a very copied from someone else or any is already published in any other document. They can file and it is called patent application. If you want to file express request for the PC application, you can file even for the expanded examination, which is startup choosing India as an ISA or IPR, International Research Authority or International Preliminary Exams Authority, if you are choosing, or if you are a government body, or if you are a one of the applicant, then you can file expanded examination, wherein you are supposed to pay 8,000 for individual and 60,000 for the company. Then you can get a patent within a month. These are the various forms you can download from the IPR.NIC.in, and if you want to file online, IPRonline.co.in with your ID, and if you have a signature of class or class 2 from your plan, then you can file that using your ID. It is the overall procedure for filing. Once you file a patent application, let's go for the digitization. Once you digitize, take for the screening of classification. Screening is classification is based on subject. Follow the international patent classing system to classify the application. Because ours is an online system, automatically files are gone to the particular field of exams. Electronics, electrical, biotechnology, microbiology, biochemistry, pharma. Depending on the classification, automatically software sent to the file not exam is not directly designed. We never skip the given row also. It's on systematically one by one. Those who file first, they will be served first. Therefore, screening and classification passes. Again, in that application, we check for the early publication, how many of file. And we give within a 1 week or within the last at most 8 weeks, within 1 month, publish for that. For that application, pre-grant opportunity will come. That is by way of any person can. And those who are not registered for early publication, wait for the 8 months, then we go for the publication. And we check whether we have requested for filing, request for examination or not. That is, you are supposed to file 40 weeks from the date of filing or prior. If you are not filed the form 18, it is treated as withdrawn by the applicant. You will not examine the application. But the interested person can file the request for examination if you are not filed. I'll tell you who is the interested person. Now, again, once the publication is over, the grant may file up to the grant of the patent. If the request came, let's go for the allotment of the patent. These are respective rules. It goes to the examiner. The examiner examining the case, search in different database and try to find out is it novel, is it fulfilling the requirement of unit step, and whether it is still applicable, and other sections 3 and 4 checks with the anticipation and put the report to the control. Control again search if you want, or if you satisfied with the examiner, follow the same report by addition or deletion and send to the called FER, first examination. You are supposed to reply within 6 months from the date of the FER reply. If you are unable to reply, you can take 3-month extension by filing form 4 and take the discussions. At the most, you are supposed to reply within 1 month. It's not reply, it's abandoned. Once Once you reply, again our examiner will examine and he or she examine whether whatever the objection we raise will substantially written the reply for that. Again they are not satisfied, they raise the objection. Then controller may call for the hearing or on his own can do the second exemption also. But mostly we call for the hearing because we don't want to keep on pending. Call you directly for the hearing now because of course they are taking online hearings. And by discussion with sitting in front of you convey how it is now in unity or the cited documents of the FER. Then if any opposition comes, then we deal with that the sent opposition comes to us the applicant. Then we again do the reply for that. Give the opportunity here hearing we decide whether we have to amend or reject the application or grant the application. Once the granted, again in 1 year from the date of publication of the grant, post grant application will come. If somebody wants to put, only interested person can. Here, interested person is, for example, COVID vaccine. That vaccine is also in pharma company. Bharat Serum is also working. Bharat Biotech is working. Serum Institute of Pune is also working. Same biotech manufacturing. That person or that company is interested in the mechanical invention. The mechanical company only has to put an opposition in the post grant. That is, therefore, it's called interested person. It's the difference between pre-grant and post-grant. Pre-grant, any person can oppose, but in post-grant, only interested person can oppose. Then, depend upon that, once the opposition comes, we make the opposition board. New officers will come and consider the opposition board, give the recommendations on the opposition. And what are the opponent grounds? Communicate to the applicant by the reply form. Same reply we communicate to the opponent, he again give the reply. Taking all the documents, we give the opportunity here in the office. In the hearing, we decide, taking the consider of the opposition of the board recommendation, whether we have to amend, reject, or grant. Depend upon the merit, it will be granted. If it is not having the merit, it will be rejected. What is the role of patent system? Encourage for the improvement of technology, providing reward as an exclusive right for disclosure. Therefore, you have to disclose everything fully, particularly as per section 10 of the patent. Making profit or earning royalty through putting the invention into practice. Don't keep invention on the namesake. Don't take for the project work. You have to put in the invention the practice so that you can earn like it. Transferring into public property after expiry of term or cessation of term. Once it is done expiry, it is in the public property. By knowing different kind of intellectual properties, how to draft the application, how to file the application, let us see what to do. State the benefit of patent system. Everywhere where you give the get the opportunity to state the benefit of patent system. Utilize resources to the organized arrangement. Always use the resource to arrange. Capture the global market judicially, not as it is for something to come in the market. Capture it by taking trademark for the name, design registration, technology patenting, and insurance copyright infringing your organization. Anything, if you want to come in the market, protect your so that you can earn like nobody will compete for your business, startup, or anything. Earn profit through protecting market. Definitely don't come in the market. Thank you. Any doubts? The session is most welcome for you.
Thanks a lot. It was a very interesting and informative session. And if we have any queries, so we'll see for and even you have very elaborately explained the study maximum.
Now, madam, your audio is not clear. Now, madam, kindly reconnect.
Please reconnect.
You are not audible, ma'am.
Yes, I am audible.
Now, sir. Now, Okay, thanks a lot, sir, Bharat sir, for your enriching and informative session. And you have very elaborately explained all the details pertaining to IPR and the patent process specifically. And if in case we'll have any queries, so we'll seek your inputs via mail, and definitely we need your go forward in this particular area.
Yes, ma'am.
And yeah. And sir, we also know that there's need to protect the tradition.
Madam, you are not audible again. Hello.
Well, we are not audible again.
Sir, now? Okay.
Yes, audible.
Okay, sir. Thanks once technical expert, Dr. Bharat M. Suryavanshi, sir, for sparing his time and working so hard in this particular area and giving his inputs and insights on IPR and the patent process. With it, also, I'd like to thank our respected principal, sir, CEO, sir, EO, sir, registrar, sir, all deans, HODs, IIT convener, Professor Sampath Kumar V, Professor and TPO Dr. Yogen Singh, IIT members, faculty members, and especially students for actively participating in this session. So thanks a lot. We'll meet again with a very interesting and enriching session via IIT session. Thanks a lot.
Thank you, sir. Sir, with your permission, Sampath sir, can we close, sir?
Yeah, thank you very much, Dr. Bharat Suryavanshi.
Thank you, sir.
It was a wonderful session we had, and definitely we will utilize your experience, your organization's support, and once we come out of the COVID, definitely we will invite you to visit our campus. We had our giant director. This whole week, our principal sir, everybody was busy, and because of that, principal sir couldn't join this session. And next session, definitely he will be there. And once everything, we come out of the pandemic, we will invite you to visit our campus. Thank you very much for your valuable time. And I want to thank Dr. Yogendra Singh connecting IIC to you. And feel free, it is your extended family, and we need your support and guidance always. Thank you very much, sir. And I want to thank all HODs and all deans who have spared their time. And also, I want to give special thanks to Mr. Tilak, who has taken a lot of effort in bringing this Zoom meeting, and also parallelly the meeting of the session on live on YouTube. So thank you very much, Tilak, for your efforts. And Sapna madam, thank you very much. On behalf of IIC, I want to thank you for your encouragement words, and also the way you introduce the guests to all the participants. I want to thank you, ma'am. And definitely we will work as a team, and we will bring a few more sessions from Dr. Bharat Suryavanshi to all our students. So thank you, sir. Thank you once again.
Thank you, sir. Thank you.
Sapna madam, with sir's permission, and you can end the meeting, madam.
I request Tilak sir to kindly call off the meeting. Sir, with your permission, Bharat sir, can we call off the meeting?
Yes, sir. Yes, sir. Thank you, sir. I am absolutely. Thank you so much.
Thank you very much, sir. Thank you, Bharat sir, Sampath sir, Sabna madam, Tilak sir, and all.